Is everybody ready? All right, please have a seat. The next case is MB Doral, LLC versus Florida Department of Business and Professional Regulation. Mr. Terminelli, you doing this? Mr. Martinez is going to do it. Okay. Mr. Martinez, you may proceed.
May it please the court. Your Honor, I request 5 minutes to be saved for the conclusion. Michael Martinez, the Green Spoon Murder, and I am representing MB Doral LLC Martini Bar. In this case, Martini Bar has a full liquor license authorizing the sale of beer, wine, and spirits. This is a license that is purchased on the open market. It's a limited number based on population. For example, in Leon County, these licenses go for approximately $500,000. It is the only beverage license which is purchased on the open market and has that kind of investment required to get into it. Other retail license types would be gas stations, grocery stores. There are specialty licenses which allow the sale of liquor, which do not require this purchase, such as those are based on the predominant nature of the business, like a restaurant or a bowling alley or a fraternal organization, for example. But in Florida, we have an overall statutory scheme of 3-tier. So it's manufacturing, distributing, and retailing. And the alcohol flows down. So a retailer can only purchase product from a distributor. They cannot get it from the manufacturer. Therefore, the distributor has a statutory monopoly. And in regards to malt beverage, they have an even tighter grip on this monopoly because they have something that are called exclusive sales territories. What that means is their brand, the distributor will hold a brand, and they're the only one that can sell that brand within that territory. So example, it might be Bud Light. If Bud Light has a territory of Tallahassee or Leon County, then there's only one distributor that can sell it to any retailer. And even though they have that monopoly, there's no obligation to actually sell it to the retailer. So it's always a voluntary decision on their part to make a sale in regards to any types of beverage statutory obligation. So that really brings us to why we're here. Martini Bar's goal is to service large events and to sell a lot of product for these distributors. And their goal is to maximize profitability by avoiding delivery costs.
Can I ask you a question about that?
Yes.
You've presented as 3 different issues. One, whether the licensed premises definition captures the catered event location. And then second, which I guess is and I guess if you prevail on that, then that's all you need because then you can deliver. But then you've made a separate argument just going to the delivery irrespective of how the first issue comes out. If you were to prevail on the issue of whether you can deliver or whether you can have the others deliver, is the licensed premises statutory definition and whether these catered event locations fit into that, is that relevant? Is that part of your claim still? Is there some other import of that issue?
Not really, Your Honor. If a delivery, which it can be made to any location, then it's somewhat irrelevant as to it being a licensed premises. It wouldn't make sense in the statutory scheme because of the statutory requirement that sales can only take place on a licensed premises, and there's numerous other reasons as a practical implementation matter that the division should want it to be a licensed premises in regards to responsibility of the conduct of patrons, for example.
But from your perspective and your appeal, there's no other reason.
That's correct.
That's the whole reason you're. Okay. I just wanted to make sure I understood that correctly.
Okay. So, in order to get clarity, Martini Bar filed a request for declaratory statement, allowing us to get. We are substantially affected. There's been no dispute as to that. We wanted to get an opinion as to our facts as they apply with the statutes, and the facts. The petitioner must present the facts as they apply to them, but it is not required that they be exclusive to the petitioner. That's obviously built into the process because these are noticed to the industry. There would be no requirement to notice them if it didn't affect them, and in fact, there's case law which is stated to that effect. The statutory revision, the removal of the term only, obviously indicates that it can apply to more than one particular licensee's location. And they have a right to a binding decision. That's pursuant to the Florida Department of Business and Professional Regulation, Division of Parimutuel Wagering versus Investment Corp. In that
Can
case,
the retail licensee ship, could you ship from your licensed premises to the place that you're staffing the catering event?
according to the division's construction, the answer would be no. Because it's not a licensed premises, you cannot ship the product to that location. Deliveries away from a licensed premises must be made for sales that actually occur on the licensed premises. Therefore, when creating the delivery section of statutes, Florida Statute 56157, the legislature realized that there was an evolution of the process of alcoholic beverages. There's phone orders. Recently, it was amended with an internet orders. Essentially, that's what electronic is interpreted to mean, emails and whatnot. But they can't make a delivery away from their location unless the sale actually occurred at the licensed premises.
What about storage? The statute talks about, the place of storage, but then it also uses the term storage within a licensed premises. So can you have a sort of an off-site warehouse or something, you as a retailer?
As a retailer, you can store product on your licensed premises, or you have to obtain an off-premises permit, which is authorized by the division to allow you to have storage at a location other than your licensed premises. So those are the two situations in which storage can take place. But the statutes that deal with...
And that off-site storage would not be a licensed premises?
Off-site storage is actually a permit under the beverage law. It is not considered licensed premises for purposes of sale. In other words, it doesn't authorize the sale of alcoholic beverages. So it is licensed. I think it depends on the term of what licensed premises means. There's a couple different ways to look at it. But essentially, no, it's not a licensed premises. You're not authorized to make sales at your warehouse. You can only make sales on the licensed premises pursuant to Florida statute. So as we mentioned, when we look at the statutes that apply to what a licensed premises is and interpret it, 56206 talks about, as we previously mentioned, sales only on the licensed premises, the plain language of that. The statute which the general law authorizing a quota licensee, a full liquor licensee like Martini Bar to cater, talks about their ability to sell on the licensed premises or on the premises of a catered event. So they have the ability to sell alcohol there, and you can only sell alcohol if it is, in fact, a licensed premises. We previously discussed the delivery issue, and so in order to, the bedrock principle of sales only occurring on a licensed premises, the legislature, when they modified, and again recently the statute on delivery, by operation of law, they make the sale take place on the licensed premises even when the actual elements of the sale do not occur there. So in other words, if a consumer places an order and online, the order would actually go into the store itself. At that point, an employee or actually now a third-party entity could drive to the individual's home, exchange and transfer the product, which is one of the elements of sale, and receive the consideration at that point. So the actual sale is physically taking place at the location of this interaction, which is usually somebody's home. But by operation of law, it's occurring at the licensed premises, again, because it's just a bedrock principle that sales have to take place at a licensed premises. That's always been the construction. If you look at the actual definition of licensed premises, they have to invalidate a portion of the statute in order to make their construction work when they create the scheme out of whole cloth. The statute itself talks about the physical location, the land surrounding it, potentially sidewalks, the building, the interior rooms. But it goes on to say, in addition, so clearly separate from, in addition to that included or designated by general law. The division makes a couple vague references in regards to the outside contiguous area and the sidewalks, and it claims that that's what this language is referencing. But that construction fails because the outside area and the sidewalk has to go on the sketch, right within the definition of licensed premises. It has to be included. So obviously, they're referencing something else.
Well, aren't there all kinds of other things, something about county fairs and things like that? I mean, if you go through the code, aren't there other aspects of where people can sell this stuff that's not on licensed premises?
There are times where there are places where you can make sales, but when you're making sales and it's authorized by statute, it's authorized by general law, and that it is a licensed premises, that would be our position. For example, there are other sections which, in this case, the general law which authorizes a sale is the catered event. So that is authorizing sales at that location. And since sales can only take place on a licensed premises, it has to be a licensed premises. So those other sections that authorize it, we would postulate that you are in fact responsible for the conduct that occurs. That is your licensed premises at that time in those locations. There are examples, other examples of licenses, to your point, which authorize sales in remote locations which do not have a requirement for a physical sketch to be submitted.
Well, there's no question that the law, I mean, I don't think anyone disputes that you can sell at locations that don't have a physical sketch. I mean, I don't understand their argument to be that their argument, I think, is that the catered event location is not a licensed premises, but that you are permitted to sell there.
Right, that's the confusing part, is what they're saying is it's a licensed premises. There's this place of business situation, but is a place of business which allows sales, but is not a licensed premises, without being able to point to that. And what they're arguing is that what is a licensed premises is what's included on the sketch. It has to be included on a sketch, or it's not a licensed premises. But the problem they have and they can't deal with is there's numerous locations that are not required to have a sketch and authorize sales.
But I think the way they deal with that is by saying under the statutory definition of licensed premises, it does not include what your client does, but that the legislature has said you can sell on a licensed premises. You can also sell at a catered event if there's a caterer there selling food or whatever the statute says, and that those two things coexist so that there's at least two places you can sell liquor, on a licensed premises or at a catered event.
Right, well, they say that, but unfortunately they are unable to explain why the statutory definition of sale on a licensed premises is so restrictive, and that there are other locations and licensees that never have a physical location, nor do they ever have a sketch. They can't address railway cars, they can't address planes, they can't address cruise ships, they can't address buses, and there's another specialty licenses that's issued to caterers, which is predominantly a food licensee, which must obtain more revenue from food than alcohol at every single catered event. They're never required to get a sketch whatsoever at any location, nor are any of these other entities. So apparently they would say that all these sales all over the state all the time are all occurring on unlicensed premises, and they continuously discuss any kind of specific authorization, but they can't point to any statute which supports this contention of a place of business substitute which allows the sales. And in fact, they cite a case, they misinterpret Boynton v. State. They hold that for a case that says there is two distinct situations. There's a licensed premises, and then there's a place of business. Well, that much is true, but the case actually holds that place of business is the area which you cannot make the sale. In other words, the search was valid because it was in a place of business, even though it was not in the area where a sale can take place, because the licensed premises is where sales occur. That's always the case. When you look at the disciplinary statute and the conduct of patrons, they make cases every day for patrons having misconduct. If they're openly smoking cannabis, that conduct, that is unaddressed under this scheme, this scheme. If there is if there are other types of violations, it wouldn't be the responsibility of the licensee in this scenario, because it's not a licensed premises, which just is antithetical to everything that the beverage law stands with. It's a privilege that you have to, you have an obligation to maintain control and to monitor your licensed premises, and that's exactly what this is. And when we look at the issues of delivery, because of the beverage law and the three-tier system, you can only get a product, you can only receive a product if it can be delivered to you. So they're interrelated. It's inseparable. And when we look at the statutes that deal with delivery, they're incredibly broad. I mean, distributors are allowed to distribute from one place in the state to another place in the state. There's no restriction. Deliveries made by a manufacturer distributor away from their place of business is not restricted. But what's interesting is they keep saying there's no specific or authorization for sale to a catered premises. There's no explicit authorization for sale to a licensed premises or to a storage. There's nothing in the distribution statutes that actually authorize that. So they claim they have to have specificity for this one particular situation, and yet they themselves admit that delivery is authorized, that it's not a tied house violation fundamentally if you have the delivery going to a licensed premises or off-premise storage permit, as does the intervener similarly argue that there are numerous statutes which state that's the only place they can deliver, but they are unable to cite to even one such provision. Thank you.
May it please the court. Good morning. My name is Ross Marshman, and I represent the appellee, the Department of Business and Professional Regulation, Division of Alcoholic Beverages and Tobacco. Seated with me at counselor's table is Attorney Thomas Crabb, who represents the appellee interveners in this case. I will endeavor to use approximately 15 minutes of the total allotted time and cede the remainder to Mr. Crabb. I'd like to start by addressing a question that Judge Roberts asked of the appellant, which is, how can a vendor receive alcoholic beverages at the premises of a catered event? The department maintains that 561.571 permits a vendor to transport the beverages from its licensed premises to the premises of a catered event, so long as the sale is construed as having taken place at the actual brick and mortar of the licensed premises. That is how the alcoholic beverages can arrive at the premises of a catered event.
The sale at the catered event? The sale at the catered event? If you have a catered event and you have a cash bar, where does the sale occur?
So the host of the catered event places the order with the vendor for the alcoholic beverages to be brought to the premises of the catered event. And the department maintains that the vendor at the premises of the catered event would be acting as the agent of the consumer and doling out the alcoholic beverages on behalf of the consumer at the premises of the catered event. So long as the actual sale is construed as taking place as a licensed premises, which we think it would in this case,
The sale from the consumer to the sale to the consumer from the vendor at a wedding or something, you're saying would take place at the licensed premises back at the Martini Bar?
Perhaps I misspoke, so just to...
Maybe I misunderstood.
No, I just want to make sure this is
Sure.
clear because this is pretty important. All right, so 561.20 permits a vendor to sell alcoholic beverages at the premises of a catered event, so long as those premises also have a caterer under 509 present as well.
Okay.
Okay. So the department believes that a vendor can transport its alcoholic beverages from its licensed premises or permitted off-site storage to the premises of a catered event. That's authorized by 561.571. They are allowed to transport their own beverages so long as the sale is construed as having taken place at their licensed premises. So to answer
the sale between the distributor and the vendor, or the sale between the vendor and the drinker of the alcohol?
This is where I was less than clear in the beginning.
Okay, sorry.
No, it's the department's fault. The department construes the sale between the consumer and the vendor having taken place at the licensed premises of the vendor itself, which is...
And why does it do that? Because I thought you just said that under the statute, the vendor was authorized to sell alcohol at a catered event if there was catering going on and all the other requirements that go with that. So what is the purpose of construing it that way? In other words, is a vendor allowed to sell, if we say, well, the sale you're talking about at a wedding would take place at the wedding, is that an impermissible sale?
Under 561.20.2A5, no, that would not be an impermissible sale, because again, the quota licensee in this case, the appellant, has that exception under 561.20 to make the sale at that location.
Okay.
So I guess I got off track by trying to answer the judge's question instead of sticking to my plan, so I apologize. But the sale should be construed according to 561.22A5, which permits the sale at the licensed premises between the vendor and the consumer.
Okay. And I don't want to get you further off track, but I had one quick question. The constitutional amendment that goes into effect about the agency deference, is there any question about whether that applies here?
No, Your Honor. The department believes that that amendment has changed the standard of review in this case. We're not going to argue that it hasn't. So this case is not as simple as to be solved by just reading one section of the beverage law itself. It can't be solved by just looking at the definition of a licensed premise, and it can't be solved by just looking at the exception. It has to be taken as a whole. So the department will be discussing provisions from the administration chapter as well as the enforcement chapter, both basically the same ones that were discussed by the appellant. First and foremost is the definition of a vendor's licensed premise and why that is not the same as, say, the catered event premises. 561.01 subsection 11 defines the specific physical location of the licensed premise, the building, the sidewalk, whatever is contained in the sketch that has to be included in the initial application that's submitted to the department for licensure. The department needs that physical address and principal licensed premises for regulatory functions, inspections, and things like that. 562.03 prohibits a vendor from storing or keeping alcoholic beverages anywhere but for the licensed premises or its permitted off-site storage. And likewise, ordinarily a vendor would be prohibited from selling alcoholic beverages away from its licensed premises, according to 562.06. Returning back to the quota licensee exception, 561.22A5, the licensed caterer or a so-called quota licensee can serve alcoholic beverages for consumption on the premises of a catered event. But that doesn't mean that a licensed premises and the premises of a catered event are the same. There's no indication in 561.22A5 that the legislature intended for that exception to be under the umbrella of a licensed premise. The appellant makes an argument that the licensed premises can be expanded as required by general law, which is in the definition. Those general law exceptions are found elsewhere in the beverage law. Those are found in chapter 565.06, or excuse me, 565.02, subsection 6 and 7. The beverage law specifically describes the enclosures of I believe a theme park and a marine exhibition area. And that specifically, by the beverage law, is included in the vendor's licensed premises, where otherwise it would not. So those are the types of general laws that the department maintains would describe the licensed premises, not the premises of a catered event. Again, the quota exception is silent as to whether or not this should be construed as part of the licensed premises. Instead, it's an exception to the otherwise prohibition from selling anywhere but for the licensed premises.
I wonder if you could address the last point that the appellant's counsel made about the delivery. If I understand your position correctly from the briefs, it's that you cannot, a distributor cannot deliver anywhere that's not specifically authorized by statute. Is that right? I mean, there's no statute that explicitly prohibits what they're trying to do, which is to have a distributor deliver to we'll call it the wedding. Is that correct, that there's no statute that explicitly prohibits that?
So, two things in response to that, Judge Windsor. First is the petition is from a vendor in this case. So the department was only tasked with addressing where a vendor can receive alcoholic beverages. We were not tasked with deciding where a distributor can deliver its alcoholic beverages.
Okay.
But addressing the second part of your question, however, the department believes that while there is no single statutory provision that describes the scenario, again, the beverage law taken as a whole, reading 561.56, 561.57, the transport and delivery, in conjunction with 562.07, which describes the illegal transport, those are the statutes that would answer Your Honor's question regarding whether or not a distributor can go towards that. And we've previously maintained in other cases that they cannot deliver anywhere outside of their licensed premises or the vendor's licensed premises. Does that answer Your Honor's
Well,
question?
I understand that you've maintained that. I guess what I'm struggling to understand is how, if you could maybe walk us through those statutes as to how we get to a point where Florida law prohibits the license holder from receiving the alcohol at we'll call it the wedding.
Yes, Your Honor. So again, we have to look at this from the vendor's perspective because this is their declaratory statement here.
Right.
So the statutes I'm going to list are limiting where the vendor can receive the alcoholic beverages, not where the distributor can deliver, but where the vendor can receive.
Understood.
So under 56203, a vendor can only have alcohol on the premises of its licensed premises or its off-site permitted storage. That's the limit on where a vendor can maintain its alcoholic beverages. And again, looking relatedly at 56206, they can only sell alcoholic beverages from the premises that are licensed. So,
What was the, let's start the first one. The 56203 says you can only have it at your licensed premises or permitted off-site storage.
correct. It says you may only store or keep, not for personal possession, alcoholic beverages at your licensed premises or permitted off-site storage.
Okay, but your position is they can take it there to the wedding when they're going to sell it there. I mean, that statute wouldn't preclude, I don't want to put words in your mouth, but that statute wouldn't preclude them taking alcohol to the wedding. I mean, you wouldn't say, well, you're now storing it under the table at the wedding, and so that's prohibited.
So the department believes that 56203 does not prohibit a vendor from transporting the alcoholic beverages to the wedding. And
Or
that,
keeping it at the wedding during the wedding, right, I assume.
right, there are some other provisions in 56122A5 that describe how the alcohol is to be treated after the wedding, so to speak, is handled. But again, 56203 in conjunction with 56157, we believe that is the authority that would allow a vendor to bring the alcoholic beverages to the wedding.
Okay.
So going back to 56122A5, it really pertains to an exception to where the beverages can be sold. It doesn't state how the beverages can be transported to and from the catered event. It really provides an exception to what we were just discussing, Judge Windsor, which was 56203, 56206. That is where the quota really, the exemption really lies. It's not describing how the distributor can transport alcohol in any way. 56122A5 is only describing the licensed caterer in the first part of the paragraph and the vendor in the second part of the paragraph. It's silent as to the distributor. So again, we believe the restrictions on where the vendor can serve or keep alcohol would prohibit them otherwise from having this privilege anywhere else but the premises of a catered event or as designated by general law. Just briefly touching on the tied house evil provisions. In the briefs, it was argued that the department should have answered the question whether or not this delivery scheme or vendor acceptance plan was violated of the tied house evil in 5614142. The department believes that there are missing details about this plan that would decide the question one way or another, and without those details, we can't reach this. The case cited by the appellants in their reply brief had a more detailed plan. It involved split cases, and it described whether or not the fees would go up or down, or whether the fees were available to all or not. In this case, before the department, the only thing we were asked was, can a vendor accept a delivery from a distributor at the premises of a catered event? It doesn't describe the frequency. It doesn't describe whether that service would be available to all vendors in all areas, how much that would cost, how much it wouldn't cost if they didn't do it. Would all vendors have that? These details matter. You know, the beverage law has 8 different chapters of Florida statutes, and tied house evil has its own entire section, and the details matter in cases like this. And without those details, the department cannot issue anything in this case other than a broad statement of general applicability, which is not something that is contemplated by the declaratory statement under 12565.
Let me ask the similar question what I asked the other side. If what they've presented as issue 2 doesn't require resolution of this licensed premises definition issue, if they are correct that regardless of whether that's considered a licensed premises or not, that deliveries can be made there, from the department's perspective, are there other reasons why the designation of licensed premises would matter in this case?
So if the court finds for the appellant on the first issue.
On the second issue.
The second issue.
The first issue, if I'm remembering correctly, is the definition of licensed premises.
Correct.
And it seems like what they're really asking, what the declaratory request could have been, may we get the deliveries directly to the wedding, but they did it in these separate ways. And so my question is, if the statutes don't prohibit the delivery to an unlicensed premises, which is the wedding, then is there, from the department's perspective, a need to decide whether the wedding is a licensed premises? Are there other aspects of this case where that would matter?
I think I understand your question, Judge.
It was not a great question. I acknowledge that.
Well, these haven't been great answers. So, from the department's perspective, if the court finds for the appellant as to only the second issue, which is that the beverage law as a whole does not prohibit the delivery by a distributor to the premises of a catered event, then you would not have to really address whether or not the premises of a catered event is the same as a licensed premise. I don't think that you would necessarily have to have that, but again, the department maintains that other provisions of the beverage law would restrict that delivery. So it's not just as simple as comparing 561.20 to 561.01's definition of licensed premise. You have to look at the enforcement provisions.
Oh, I understand that, yeah. I wasn't suggesting that's the right resolution. I'm just trying to understand the different arguments.
So for these reasons overall, and for the reasons that the department made in its briefs, the department believes that this court should affirm the department's declaratory statement, and I would cede the remainder of my time to Mr. Crabb. Thank you.
Good morning. May it please the court. My name is Tom Crabb, and I represent the Applee Distributor Associations. I know the time is short, so I'll be brief. First point that I wanted to make, the reason why we got involved in this case is for the question of whether distributors can distribute directly to the locations of catered events. And this is not a question, we intervene because this is not a question that we as distributor associations have asked, and it's not a question that any of our members have asked, but rather it's a question that a vendor has asked, which in our view makes it inappropriate for resolution by a deck statement issued to a vendor to essentially determine the conduct of distributors. Moreover, the effect of Martini Bar's request is to create a policy of general applicability to the entire industry, and that this would not apply just to Martini Bar in its particular set of circumstances, but would instead apply to all distributors and to all quota license vendors who sell or serve at catered events. And so for that reason as well, we believe it's inappropriate for resolution by deck statement.
Has anyone asked for rulemaking? Is there any rulemaking requested or contemplated on this issue or needed?
That's an excellent question, Judge Kelsey. There actually was that would be best deferred to rulemaking because it's a policy, because it is an issue of general applicability, not unique to Martini Bar. It would be more appropriate for either rulemaking or for more legislative action. Quickly, I wanted to touch on the definition of licensed premises. Martini Bar wants to get its catered event location into the definition of licensed premises by the very last clause in that definition that says, in addition to that, included or designated by general law. and that it doesn't meet the sketch requirement. The division is unaware of where exactly these catered event locations are going to be, which creates a whole host of problems for distributors in and of itself. But they try to get it into the definition by the last clause, in addition to that, included or designated by general law. And I wanted to give you two examples of where the legislature did that so you could compare it to the catered event exception. And that's in 56502 subsection 6 that provides for the issuance of a vendor license to a theme park upon which, quote, the enclosed area within the theme park shall be considered an extension of the licensed premises. The enclosed area within the theme park shall be considered an extension of the licensed premises. And in the same subsection for marine exhibition parks, the enclosed area within the marine exhibition park shall be considered the licensed premises. So those are two examples where by general law, the legislature specifically said, here are two places that are going to be part of the licensed premises. They're not included on the sketch necessarily or fall into the other part of the definition, but the entire boundary of SeaWorld, the entire boundary of the Magic Kingdom is going to be considered part of the licensed premises, as opposed to the catered event exception that first doesn't refer to a specific area, because it could be anywhere. It could be the rotunda outside this courtroom for a few hours for a catered event, and then be somewhere else later this afternoon, and then does not specifically mention the licensed premises as those other two examples do. The other thing I wanted to mention is that distributors need to be able to verify the authenticity of the locations at which we deliver alcoholic beverages. But of course, there's no industry more heavily regulated than the alcoholic beverage industry. And the premises of catered event locations are unknown to the division. Unlike the licensed premises, I'm sorry, may I have a minute, Your Honor, to finish? Sure. Unlike the licensed premises or an off-site storage facility that's specifically embodied in a sketch or an application, the premises of a catered event is completely unknown and changing. And so for us as distributors, to distribute this product that's heavily controlled, we need to be able to verify that this is a legitimate location for this transaction, and we have no means to verify that with vendor locations, or with catered event locations.
Thank you.
Thank you, Your Honors.
Please the court. So they right away rush into head-on the very difficult situation, and that is, how is this not a licensed premises of sales or authorized? And so what they bring up is agent for the consumer, because they need to find a way to say that this sale, and as properly pointed out by the court, the sales are, in these situations, in these large events, are cash sales directly to the consumer. You're talking about tens of thousands of people buying product and individual sales at that location. So they bring up agent for the consumer because that's an exception whereby someone else can buy for somebody that does not have a license. You're not required to have a license under agent for the consumer. And that provision is actually found in 61A-1. It was never really brought up, but we'll deal with it today. However, you have to have the money ahead of time. You have to have the order. You have to go to the physical location, pick up the product. This is not that. That is a real reach in this particular situation. They talk about the theme park exceptions. What's the problem with that being? It may well be one of the examples, but the problem with that is the whole theme park does go on the sketch. That's the requirement in their license. Anywhere in that area, they put the entire location on the sketch. So it is, in fact, on the application when one reviews the application for these types of licenses. And again, they are unable to address this issue of all these other places of sales that have no sketch. The trains, the planes. Well, probably the most interesting one would be the catering license for specialty. The division has no prior notice of where these locations are. There is no sketch submitted. It's the same situation. One of the interesting points that was brought up was this confusion or concern about how they could possibly deliver to such locations, which is astounding given their practice of having delivered to these locations for many, many years, as was referenced in a previous letter that was relied upon in which sales were made and deliveries were made by them to these locations. Any representation that there is some inherent problem, it doesn't make sense. If it's a licensed premises, there will be a posted license. That's a whole nother issue.
That's something I saw that you'd raised and not pursued here, I guess, but the statute is clear that, I mean, is that the practice at the wedding? Do they put up an?
It's absolutely the practice that these licenses are put up. That's exactly when enforcement goes to a big event, they want to know who the licensee is. Sometimes they don't want to tell you that they're there. Why would you want to not have a license posted so you know who the licensee is? That's completely nonsensical. The division tries to make an argument that they can request that it be produced when they arrive, but there's no requirement that they have it there if it's a place of business. That's their theory, again, is this whole secondary place of business where sales are authorized without any clarification. And they keep referring to all of these statutes, but when pressed, they couldn't point to one. Again, when they had to go back to 561-57, which is the delivery statute. And again, it requires the sale to occur on licensed premises. And that's not occurring in this case. It's not a sale for the agent, for the consumer. It just, this construction simply fails. One of the issues was that this should be properly addressed in rulemaking, that a declaratory statement shouldn't be issued on something which constitutes a rule. But the case previously cited stated that, pari-mutuel wagering case stated that if a declaratory statement ends up issuing a position which is somewhat general applicability, then the proper procedure is to go into rulemaking and issue the deck statement. You don't decline to issue the deck statement because you're entitled, the citizen is entitled to an answer. So you move forward and you issue it and you go into rulemaking. And they're saying it's inappropriate to have a rule. However, what could be more generally applicable? In this declaratory statement, they are in fact saying that any quota caterer, any quota licensee with a catered event cannot have delivery. That's general applicability to everybody with that license type.
What's the pari-mutuel case you just referenced?
I have that for the court, but it's in my other materials. I'm sorry, I've got it turned around. But there was it was. I'm sorry, Your Honor. I stated on the record previously. I apologize for not having that in front of me. With exclusive sales territory, the other problem they have, if Martini Bar were to cater in, for instance, Pensacola, the exclusive sales territory of that distributor, they could not sell the product to them because the distributor in Pensacola is going to be different than the distributor that's in Miami-Dade. And place of business, according to the division, is what a catered event is. So therefore, they can't get the delivery there. It's nonsensical. Like they can't even sell it to them. And the distributor in Miami, they can't sell them the product for a catered event in Pensacola because that's outside of their exclusive sales jurisdiction. So they've just created all these secondary effects by trying to rewrite this and to come up. And if they want to have a legislative scheme, if they want to change a legislative scheme in the beverage law, then they need to go to the legislature and have it laid out to the way that they presume and they want. But they cannot rely on the statutes. They have not relied on the statutes. Whereas we have given multiple examples of where it's authorized, why it's authorized, and why this construction fails. Thank you.
Thank you. Thank you both, all of you, for your argument. We have no other cases on the docket this morning, so we are adjourned.
All right.